Students, today we are going to start the Indian Contract 1872, and in this lecture number 1 we are going to do the introduction about the Indian Contract 1872, that how this act came into force in India. So it is very important to see that the Indian Contract Bill had been passed first of all by the legislature, and thereafter it has received its assent on 25th of April 1872 from the Governor General of India. Okay. After receiving the assent from the Governor General, it came in the statute book as the Indian Contract Act 1872. It was the ninth act of 1872, whereas it came into force on the first day of September 1872. Basically, the Indian Contract Act 1872 is based on the English common law. Basically, English common law is applicable in England in relation to the contracts. Who drafted the Indian Contract Act? It is very important question. So this act was drafted by Sir James Fitzjames Stephen, who headed the Third Indian Law Commission during the British regime. And after the independence of India, this act continued into as law in India by virtue of Article 372, clause number 1 of the Indian Constitution. And it falls under the 7th schedule, list number 3, entry number 7, along with its extensive acts like Indian Partnership Act, Transfer of Property Act, etc. Earlier, this act extended to the whole of India, but not in the state of Jammu and Kashmir. But after this Jammu and Kashmir Reorganization Act 2019, this act from 31st of October 2019 extend to the state of Jammu and Kashmir also. That means to say, now this act extend to the whole of India, including the state of Jammu and Kashmir. So, what this act contains? This act contains the general provisions or general principles of law which governs how to make the contract and what are the various provisions in relation to the contract. And nature wise, this act is substantive in nature. What is the meaning of substantive in nature? Law can be divided into two categories. First category of law is known as substantive laws, and another category of laws is known as procedural law. Substantive law basically are those laws which prescribe the right and liabilities of the parties, whereas procedural law prescribe the remedy, prescribe the procedure by which those rights and liabilities can be enforceable in the courts. Okay, so this Indian Contract Act 1872 prescribe the right and liabilities of the parties, so it can be regarded as substantive in nature, whereas the procedural law of the Indian Contract Act has been prescribed in the Civil Procedure Code 1908 as well as in the Limitation Act. Okay, but it is also very important to see here that this act is not exhaustive. That means to say this act do not cover all types of law relating to the contract. Since apart from the Indian Contract Act 1872, there are other acts which are applicable to the particular types of the contract. For example, Negotiable Instrument Act is applicable for various types of negotiable instruments. For example, bills of exchange, checks, promissory note are governed by the Negotiable Instrument Act. And if you want to sell the movable property, then Sales of Goods Act is applicable. And if you are concerned with the company matters, then Company Act is there. So, apart from the Indian Contract Act 1872, there are other acts which are specially applicable to special type of contract. So it is very important to see here that if there is any type of confliction between the provisions of Indian Contract Act 1872 and the special laws, then the provisions of special law will prevail over the provisions of the Indian Contract Act 1872. This act also do not affect any custom or usages of trade, nor it affect any incident of any contract. Okay, provided that custom, that usages of trade, that incident of contract should not be inconsistent with the provisions of this act. So this is something about the introductory part of the Indian Contract Act 1872. In the next lecture, we will discuss the meaning of the term contract. Thank you very much.